So in this video, we're going to be looking at three things. This one will likely be the shortest video that I prepared for you. You have much reading to do. And I hope you find this sort of at the culmination, at the end of both constitutional law classes, but in particular, Constitutional Law 2. I hope you find this to be intriguing. I want you to think hard about this. You have a brief, and then you have a law review article. So I just want to point out these three things. The first being this prenatal children. Guardians ad litem are already being appointed for prenatal children in certain legal contexts. This is true. There's much here. I actually want to show you Texas law. I'm going to show you an example. Before I do that, I want to point out some confusion. Oftentimes, you'll hear guardian ad litem or attorney ad litem. Sometimes they're used interchangeably, and sometimes an attorney ad litem is appointed with the dual role of being both. So an attorney ad litem can be a guardian ad litem. There can be a dual role where a single person is doing both roles, although conflicts of interest can exist. But there is a much larger class of the population who can be guardian ad litems. You don't have to be an attorney to be a guardian ad litem. Also, just a little side note here, at some point in your life, you may want to look at being a guardian ad litem. It's a very fulfilling role. It's hard work. So here's the definition out of the Family Code in Texas. So this is a particular context, but this is just really the definitions. So an attorney ad litem means an attorney who provides legal services to a person, including a child, and who owes the person the duties of undivided loyalty, confidentiality, and competent representation. The guardian ad litem means a person appointed to represent the best interests of the child. So think about this. The child may want to do something that is not in her best interest, and the guardian ad litem essentially doesn't have to listen to the child. The guardian ad litem is about the best interest of the child. The attorney ad litem may have a conflict of interest arise if the child wants to do something that might not be in her best interest. But just keep in mind, there are two separate definitions. This is in the Family Code for attorney ad litem and guardian ad litem. Now that may be getting a little bit into the weeds, but I think it's important, especially as you read through these things. Sometimes in various jurisdictions, they're not always as clear. So this is from the Property Code when we're talking about trusts, the Texas Trust Code. And this is another statute in Texas. And I want you to see this language. At any point in a proceeding, a court may appoint a guardian ad litem to represent the interest of a minor, an incapacitated, unborn, or unascertained person. Section 15.014 gives authority to court to appoint a guardian ad litem for an unborn person. Right there in the statute. So this is a very real thing. Now, also, when you're looking at this, it's not in every situation. This is in a property case, and we're talking about trusts. Trusts are oftentimes used in estate planning scenarios. So let's say husband and wife are bazillionaires, and they have 3 children. And they don't want their 3 children to get 1/3 of $1 bazillion. They want each children to be provided for, to have the education of each child paid for, to be able to support themselves out of a trust fund. And so they can set these trusts up, and then they can appoint a trustee, so a trusted friend, a lawyer, a bank, and then they can create some parameters. So a very often used parameter is health, education, maintenance, and support. So a child can use the money, whether it's interest or principal or both, for that child child's health, for the child's education, child's maintenance, or that child's support, but maybe not for a vacation. And so it's a way to put some restrictions and sort of control after you're gone, so the way that the money is handled. And so you can put this in trust, and it's also important for asset protection because the trust funds are not in the estate of the child, and that can provide some protection from creditors to some degree, and also if there is a future spouse who then becomes a past spouse. So if the child gets divorced, the trust is not part of that child's estate, therefore cannot be divided up, is not part of the marital estate. So that's a little bit of a sidebar, but just know when you have estate planning concerns, a life in being is a term of art, and it matters, and that includes unborn children from conception forward. Not every situation calls for the appointment of a guardian ad litem to an unborn child, and I want to be fair. It does exist. It does exist in Texas. I'm showing you the current law, and it certainly exists in other parts of the country, but you can understand how it might be easier to understand why an unborn child has property rights in the property code for issues of distribution of wealth inside of a family following the wishes of the original owners, whereas it might not be the case in other scenarios. Although I have a question. So in the state of Texas, as well as the United States, let me just refresh your memory. Article 1, Section 19, no citizen of this state shall be deprived of life, liberty, property, privileges or immunities, or in any manner disenfranchised except by the due course of the law of the land. So the important part here is no citizen of the state shall be deprived of life, liberty, or property. And in this case, we are talking about the property of an unborn child. We are not talking about the life of an unborn child, but it is interesting. So I want you to read this law review article. I think it has some compelling arguments. I think you will also find some things that you might disagree with. And then you're going to have a different argument. And you may wholeheartedly agree with this law review article, and the other brief may disgust you, hopefully not vice versa, but I don't expect you to have a particular reaction to these. I want you to see two sides of the argument being made, and one of them was filed in a court. These were actual arguments made. The law review article, these are arguments being made supported by evidence, but there is no court who is going to decide one way or the other. This is to influence jurisprudence, not necessarily to influence the law directly. It's an indirect approach. So it's two different ways of looking at it, but I think it's important. And this definitely has to do with the Constitution in Texas and the United States Constitution. So do pay attention. I know it's a lot of reading. I think you will find this interesting. I have assigned this to other courses before, and we've had great discussions about this. I think it's very interesting to me, and I think you will find it interesting as well. You do have to get up to speed on what an attorney ad litem or a guardian ad litem is. Just remember, guardian ad litem is independent and represents the child, either the child's best interest or the child's direct wishes, and is not a party. Doesn't represent a party per se, as it's not a party person. It's not a plaintiff or defendant. It's an independent officer of the court, which is key.